Spellman versus Shawmut Woodworking and Supply.
Mr. Glynn,
Yes.
you may proceed.
Good morning, Justices. My name is John Glynn, and I represent the appellant East Coast. This case is before the court because of the seriousness of the economic chaos it would create within the construction industry and also the potential economic doom for a significant number of subcontractors. Briefly, this is an alleged construction site slip and fall accident on a piece of plywood which is not installed by East Coast. Both liability and damages are hotly contested. There were no witnesses to the alleged accident. There were two different versions as to the time it occurred given by the plaintiff. In summary, the disagreement on damages can be described as being either equal or even greater than the disagreement on liability. As stated in our briefs, the position of the East Coast on the special questions submitted by the trial court is no to question 1. 2, if the assignment is upheld, there would be no effect or impact whatsoever on the agreement of judgment entered into by the plaintiff and the general contractor, Shawmut. And as to 3, if the agreement for judgment is void, East Coast does say that the agreement for judgment should also be void.
Can I ask you this? Let me pose the following question. What would happen if Shawmut settled for $300,000 and paid the money and sued East Coast for indemnification? What defenses would East Coast have there that are not available here?
The defense is it's a different situation. The $300,000 has been paid.
Right.
Actual loss. The cornerstone of our argument is there has to be an actual monetary loss.
So that's the only difference?
No, it's a
No other defenses?
There are other defenses. They would still have to establish that East Coast, maybe to a small degree under comparative negligence, had some type of negligence.
They'd have to establish that here as well, wouldn't they?
They still have to establish that here. Yes, they do.
But I take it that sort of slipped of a variety of things. One of your problems is that where Shawmut is not on the hook for anything, well, it hasn't been paid, correct?
Correct. They've only been out $35,000 in defense costs.
Of the $300,000, correct?
Yes.
So in essence, Shawmut, as I understand your argument, and correct me if I'm wrong, could have agreed to almost any monetary
That is correct.
loss because they were never going to be on the hook for actual payment.
That is correct, Your Honor.
Right?
Excuse me.
And from a matter of, I understand the policy reasons, but I suppose what you are assuming is that if somebody actually has to be, the assumption is if Shawmut actually paid, in Justice Cordy's hypothetical, Shawmut would pay the $300,000 and then the injured worker could sue for additional compensation?
No, if Shawmut were simply bringing the indemnification claim against East Coast, my question was what other defenses would Shawmut have there that they wouldn't have here?
That's correct.
And your only defense that you say is, well, Shawmut would have paid the money there, and here East Coast has the defense, which you are arguing here, that Shawmut hasn't paid any money, therefore there's nothing to indemnify.
It's what we bargained for in the beginning.
And I take it that to just go to the end of that so I understand, that if Shawmut did not prevail against East Coast for whatever reason, it would still have had to pay the $300,000. That's your problem here.
That is correct.
Okay, let me ask you a question. Once you accept the validity of the indemnification, which is another question, but our cases have accepted that, why does the assignment make any difference? It makes no difference who the indemnitor writes the check to, whether you write the check to the employee or whether you write it to the general contractor.
I'm not so sure I understand the question.
Okay. Why does it make a difference? You've got an indemnification that you've indemnified the Shawmut, right?
Yes.
You agree. Okay. And so you've got to pay, why does it make a difference whether you pay Shawmut or whether you pay the employee? You've got to pay,
We have to pay for actual loss. We have to pay for, they have to lose it. When we started out,
so it all boils down to actual loss, that you say there isn't a loss, they've just agreed to lose the money.
they agreed to a figure that they agreed upon. We didn't agree upon this figure, but more importantly, they didn't pay it, and they'll never have to pay it. And when we start this contract, put the parties in the beginning. My client, East Coast, to get the work, has to agree to defend and indemnify for actual losses and defense costs if certain events occur.
If you're at fault.
If we're at fault, yes.
But that goes to my question. I take it that in that scenario, what Shawmut has to show is that you were at fault in some way, even a tiny little bit. And if they didn't prevail on that, they would be out of pocket $300,000, whereas here they are not.
That is correct, because the initial cause of action brought by Mr. Spellman, it's not based in contract, it's based in negligence. He's not worried about indemnification. All he cares is he got hurt and it's at fault, and he's pointing the finger right at Shawmut.
Well, you mentioned that, and you say at some point in your brief, East Coast wasn't involved in the settlement amount, so that's an issue. But if in fact, I mean, why would East Coast be involved in the settlement amount? The suit's against Shawmut. Shawmut settles it. Maybe they settle it for $500,000, and then they pay it, and then they come to you for indemnification. How can you complain about what the suit was settled for? Or what's your avenue for complaining about that in any case?
I'm not complaining that they picked an amount and they settled. I'm complaining about them enforcing seeking to enforce a judgment now when no money was paid.
Mr. Glenn,
That's the major difference.
can I just go back to the original contract, the indemnification, and you keep talking about actual loss?
Yes.
Does the term actual, am I not reading it? Does the term actual loss,
So I rely upon Black's Law Dictionary, and I am very familiar with the terminology. It says claims, losses.
claims damages or losses including
Correct.
attorney's fees arising out of or resulting from, well, this is a claim. Isn't this a claim?
It's a claim. But how can you put a monetary value on the word claim? Claim can be worth anything.
Well, it's worth $300,000 according to somebody.
But it's not worth $300,000 to us, which we say they can put $300, they can put $500. It's not worth that to us. We're
Now,
not paying.
here's the wonderful way that lawyers draft. In this contract, it says claims, okay, that's a claim, damages or loss. What's the difference between damages or loss?
The difference here, when you read that contract provision, because we're obligated to pay, not just what the judgment, we're obligated to pay defense. We're required to pay whatever actual losses they experience. And that's covered in that terminology, in that which you're relying upon. It doesn't mean that if they pick a number and we have a claim and we've got some defense costs incurred, therefore, you have to pay, or we're going to assign our rights, and you, by the way, you have to pay this illusory $300,000.
Couldn't you not have protect yourself, though, in the indemnification agreement by making sure that you controlled the defense in any action? Couldn't you have written in?
They demand, well, you can control the defense, but then you have to take over and assume 100%. If you agree to take the defense, you got to agree to indemnify. Because of the underlying facts, we felt that we were not responsible for this accident.
Okay, then I'm missing something. You say if you undertake the defense, then you must agree to indemnify. Didn't you agree to indemnify in this Section M?
No.
What did you do? What is this section?
There was a demand for defense indemnification. We refused to defend and indemnify.
Because you said no negligence.
We said no negligence on our part. There may have been negligence with Shawmut or somebody else who was responsible for that plywood.
Can I ask you, was there any evidence in the record? This is a reasonably complete record, I think. Everybody was deposed for all the relevant parties.
Pretty close.
Was there any evidence in the record of negligence by East Coast employees that contributed to this accident?
In my opinion, no, but it was a combination of what we considered a no-witness accident, questionable, plywood, which we had nothing to do with, that was installed either by the general or some other sub, and if you were to even believe the plaintiff, which was questionable, says he tripped on a piece of plywood coming back from lunch or walking over.
So that would be a defense that you would have against Shawmut. If Shawmut had paid the money and then turned to you for indemnification, hey, we were not at fault. Indemnification doesn't click in, right?
Yes.
And that's a defense here as well, is it not?
That is correct.
If you can understand my difficulty with the language of the contract, could you tell me what the policy implications for this are?
Yes, the policy, two statutes, Chapter 152 and Chapter 149. They are carefully drafted statutes that are almost designed exclusively for the construction industry. Compensation statute clearly was a statutory remedy that took out all the common law remedies and evidentiary burdens for an injured party. It was designed to protect the employee. It was designed also to improve employee relationships at the site, and it also permitted a subcontractor to be aware that he had to protect himself for injured parties, that he would be responsible for injured parties, and he had to go out and get compensation, pay for it himself, or get it through an insurance company. That is critical.
Other than an employee,
Okay, now I want to jump to 149.
right?
149 is arm in arm with 152, because, again, the subcontractor, in order to get on the work site, he has to agree to defend and indemnify the general. He can't get on the work site, he can't get the work.
What, Mr. Glynn, forgive me for being totally ignorant of this, but why isn't it a reasonable reading of those two statutes to say that Section M, as it applies to employees of the subcontractor, can't apply to employees of the subcontractor? Forget the actual loss, but because because then you've got a worker relationship. In other words, if I come onto the site and I slip on the plywood and I injure myself, and it turns out that it's a no witness and you say you didn't put the plywood down, but they managed to persuade some finder of the fact that East Coast was the only person on the site, there was no plywood before, and so, right? Then there's no problem. There's no workers' comp. There's no problem, right? I sue Shawmut. Shawmut turns around and asks you for indemnification, no problem. But can Section M ever apply where you've got the employee of the actual sub who executes the indemnification?
The employee...
He's an employee of East Coast, is he not?
Yeah, to answer you, yes, he is. I don't believe he actually makes the endorsement of the indemnification.
No, I understand,
but
how can we ever have that indemnification as it applies to an employee?
What you're suggesting is that, tell me if I'm correct, is that this Section M is in violation of the workers' comp provisions?
If it applies...
Right, if it applies to your employee.
If it did, but maybe I'm not understanding the question. I'll be perfectly
No, I think,
honest.
because I have the same question, and I know we have cases, particularly from the appeals court, that interpret these provisions, exactly the same ones as these, as applying to the employee of the sub. But doesn't that abrogate workers' compensation? Isn't that, we're not supposed to have that?
No, it doesn't.
Why not?
It doesn't, because it's usually viewed on a fact-to-fact situation. And he went on comp. He went on comp immediately.
I know, he gets his money. He does get his money, but you end up paying.
We end up paying through compensation insurance,
Right.
yes.
My question is, Section M starts off to the fullest extent permitted by applicable law. So we've got an out. You know, the lawyers don't quite know it, so they put a nice little caveat there. And my question, and I realize that this may be upending the whole subcontractor relationship, but where you have an employee of a sub who is injured and the sub is on the hook for workers' comp, okay?
Gotcha.
The employee is free to sue the general, correct?
Yes.
Workers' comp doesn't trump that. There's no worker relationship, so the worker here could sue Shawmut, and it's up to Shawmut to figure out how much Shawmut should pay that worker, realizing that it shouldn't pay one dime for any injury or any damages caused by East Coast, because East Coast is paying for that under workers' comp, and Shawmut is not going to be able to get so much of that from East Coast. Does that make sense to you?
It does, but they can't, under that provision. They're absolutely free to turn around, and they did sue us.
Well,
But then is this provision
that
void
correct?
as in violation of the workers' comp statute?
No,
Okay.
it's not.
Well, we'll work it all out, Mr.
I
Glenn,
don't know
but
why not.
I know it's not the argument that you made, but the actual losses one, you know.
Okay.
Thank
Okay,
The red light's going. I think I'm done. Is there anything else?
Thank you, Mr. Glenn, no.
Thank you.
Mr. Wainwright, you have 10 minutes to sort us out.
Well, I'll do my best in the time that I'm allotted, Your Honor. Good morning. If it please the Court, my name is Andy Wainwright. I represent David Spellman and his family, the co-appellee and original defendant in the case. Shawmut Woodworking and Supply is represented by Mark.
Can I
Malloy.
just ask you one procedural question? Did you
Yes, please.
seek relief as third-party beneficiaries?
No.
No.
This is a pure
No,
negligence.
this is a straight assignment of the indemnification claim, Your Honor.
No, but what about the fourth question that's raised here, or the fourth, whether the judge erred in allowing the plaintiff's motion for leave to amend the first amended complaint, which added a direct indemnity claim against third-party defendant subcontractor?
Right, and the direct indemnity claim is by virtue of the assignment.
By virtue of the
By
assignment?
virtue of the
Okay.
assignment that was given to Mr. Spellman and his family by Shawmut.
What was the basis for the suit against Shawmut? Negligent supervision?
It was it was multifactorial, but essentially it was negligent supervision of the job
Of the
site,
work site.
the non-delegable duty for overall safety provisions on the job site, and the like.
Okay.
Now, the Campion case and the majority rule is instructive on the issue of brokers' excess or brokers' claims or claims against excess insurers where there isn't sufficient insurance coverage
Yeah.
to...
But isn't Campion really distinguishable? First of all, it involved insurance, which that isn't the issue here, and in general. And secondly, it was written very, very acutely, written to apply, and carefully written to apply only to the circumstances there. It said it's a couple of times that here where there is, in a situation where the liability for the accident is reasonably clear, the primary insurer has paid the full limits of its policy and damages are substantial. So, I mean, isn't that case sort of confined to that situation?
Well, the Campion decision indicated that it was the majority rule in that type of claim, the claim against a negligent broker or an excess carrier, that such claims are freely assignable. And that's also the majority rule across the country in claims involving an insurer's refusal to defend. Now, in fact,
But this is a contract claim, and it seems to me there's a pretty persuasive argument that the intention of the parties was to ensure that Shawmut was made whole for any losses that it sustained as the general contractor that East Coast might have been responsible for.
Well,
But
I thought
Shawmut
it
hasn't sustained any losses here.
well, this is precisely Mr. Glenn's argument, and
Right, I know.
the problem with that, Your Honor, is that the direct language of the indemnification provision within the subcontract that East Coast entered does not only include indemnification for actual losses, but also indemnification for damages and claims.
Well, what does that mean?
It doesn't
How is
use
that
the
different?
term actual loss. Doesn't use, so
Well, that's exactly right. That's exactly right. It uses the term all claims, damages, and losses.
Well, certainly, yeah, they will indemnify them for all claims, damages, and losses. But what's a claim that requires indemnification if there's no cost to it?
The agreement for judgment is a claim, Your Honor, I believe.
It's a
Mr. Wainwright, can you just go right back to basics?
Okay.
Your client sues Shawmut.
Yes.
Shawmut enters into an agreement of judgment to pay $300,000,
Yes.
correct? And then enters into an assignment of rights, an agreement not to pursue satisfaction under agreement for judgment. So your client has agreed to two things. I'll assign whatever rights Shawmut is...
My client is agreement to accept the assignment.
Right.
Right.
But he also agrees not to pursue...
Shawmut. You're not going to pursue Shawmut for the
Correct.
judgment.
Right.
Correct.
Right, that's
So
the agreement.
If you pursue East Coast, correct?
Yes.
And it turns out that East Coast was not negligent,
Yes.
your client gets...
Nothing.
Right. So that the only thing that's at issue here is your client saying, I'm going to sue East Coast, right?
My client saying, I have accepted the indemnification
I'm
provision.
going to sue East Coast.
Right.
The only thing that I'm looking for is damages caused to me, the worker, by my employer. Correct? Because the only thing he's getting is anything, as I understand it, in exchange for $1 yak, 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 it's for rights and claims have brought or may have been brought against East Coast. Am I correct?
Yes, you're
Okay,
correct.
so leaving aside actual loss and the... Doesn't that run straight into workers' comp? Isn't that what your client is not allowed to do under workers' comp?
No, Your Honor.
Tell me why.
Because of the involvement of Shawmut.
Yeah, but Shawmut, your client has said, I'm not looking to Shawmut for one dime.
My client had to create a record. My client had to bring the claim against Shawmut. Shawmut defended the claim. A record was created. Depositions were taken.
Yeah.
Expert witness designations were made. And under the Restatement 57, Restatement of Judgments 57, as well as the Fireside Motors case, the Monadnock fireworks display case, and the New York New Haven Railroad versus Tileston case, where a claim has been made and a demand for defense and indemnification has been made, and it's specifically under the Restatement of Torts, where the case has been defended by the primary defendant with due diligence and reasonable prudence, that the ultimate indemnitor is to be held responsible for the result.
So do I take it that the only damages that your client is looking for are his out-of-pocket expenses in engaging in this litigation?
No, Your Honor.
No, I understand you're looking for damages he suffered as a result of his injuries, correct?
I'm looking for the claims.
You're looking for $300,000.
Correct.
Now,
Correct. Plus the $35,000 that Shawmut has also...
Which you could not have recovered against, which your client could not have recovered. Forget the costs of litigation. The $300,000, let's assume for one moment that $275,000 of that are for his injuries. $25,000 is for the litigation. Under the workers' comp statute, he could not have obtained $275,000 from East Coast, correct? In a straight...
Not in a direct action. You're absolutely right, Your Honor.
Okay.
now, can I ask you two things? First, if he recovers, if East Coast litigates this and he recovers, and East Coast is found at fault, but he recovers only $150,000 against East Coast, is that all you get?
Yes. You've just told me that.
Well, that type of scenario, Your Honor, would require that the issues being litigated are not simply whether or not the indemnification provision applies and whether or not my client can collect the agreement for judgment.
No, we're
but whether or
litigating.
not
We're
damages
litigating the amount of damages.
That's right.
No, you say you're not. You say that...
I'm saying I'm not. Absolutely right.
You're going to
So-
come in with a stipulation, and you're going to say to the judge, Judge, I don't want to hear anything about damages. It's $300,000, correct? That's what you're going to do, right?
Ideally, yes.
I don't think it works that way. But
And
now
the only issue
the
is what...
second question.
Well, if we look at an analogy to
But if you take Justice Graney's view, then that would make the indemnification agreement worthless, wouldn't it?
No, because you're going to litigate negligence. You're going to come in and you say, I'm going to show that East Coast was negligent. That's what you think you're litigating,
Yes.
correct? And once you establish that East Coast was negligent, in this no witness, so on and so forth, you're going to show that East Coast was negligent, and you're going to say to the judge, don't start talking about damages. damages are set. They're set under the indemnification because we have an agreement for judgment. You can apply collateral estoppel, all kinds of things. And so once you've established negligence, it's either $300,000 or nothing, correct?
Correct.
That's all I
Correct.
Now, does East Coast Compensation Insurer have a lien?
Yes.
On this-
A
on this money?
statutory lien under Section 15 of Chapter 152. Essentially what we're talking about is moving money from the East Coast liability insurer to its workers' compensation insurer. This is a matter where...
Well, not exactly.
Well...
You mean your client isn't going to take
yes.
$150,000 out of this? 50%?
Well, under the Hunter decision...
That's why we're here.
Beg your pardon?
That's why we're here, because your client has a financial interest in this. This
Well-
isn't just insurance companies exchanging money with each other.
Well, that's that's why I'm here, Your Honor, quite frankly.
I understand that.
We thought that...
But the fact of the matter is, if we look at the situation here, where we have an indemnification provision, a demand for defense and indemnification, a refusal
By East Co-
by East
Coast,
Coast,
yep.
they participated in the litigation under the...
They participated?
Beg your pardon?
They participated?
They
in the-
participated in the litigation willingly, and they agreed in their briefs and in expert witness designations that Mr. Spellman was partially at fault. Under the DeMayo versus Kelly case, that makes East Coast responsible under the indemnification provision. That triggers the indemnification language of the contract. Therefore, East Coast is on notice that they're going to pay the full boat.
Now, they quote, willingly participated in the litigation because Shawmut brought them in, correct?
Well, but they willingly engaged in the defense, and they participated in the defense.
They didn't have a choice.
But the point, Your Honor, is that they're there, and they have the opportunity to litigate the issues, including the issue of whether or not the indemnification provision would apply.
And how about an agreement for judgment? Did they participate in that?
They did not participate in that. And, Your Honor, if again, referring to the Restatement 57, the New Hampshire-New York Railroad case, the fireworks display case, Fireside Motors, if they're given notice and they have the opportunity to defend and they abdicate that responsibility,
By not raising
by not taking over the purse strings, they have the opportunity to control the purse strings. They can take over this litigation, the defense of this litigation. In fact, they were asked to do so twice and refused. They had the opportunity to cut the losses. They refused to do that.
Okay.
Thank you very much.
Thank you, Mr. Wainwright. Mr. Lavoie?
May it please the Court, Your Honors, Mark Lavoie on behalf of the defendant Shawmut Woodworking and Supply Company. Your Honors, the Shawmut's position essentially is that the assignment that it gave to the plaintiff is valid, and its agreement not to execute is valid. It's consistent with Campione. And there is no decision in this state, Commonwealth which would invalidate the fact that two parties can make an assignment of a claim.
How do we know that the agreement for judgment isn't a scam and it was something that was essentially a pass-through to go after East Coast, perhaps in violation of Chapter 152? Is it because of the last thing that Mr. Wainwright just said? Because East Coast could have stepped in and defended this case, and would have had a voice in that agreement for judgment?
It's several things, Your Honor. East Coast did have the opportunity, as Mr. Wainwright noted, to intervene and assume the defense of Shawmut. They could have assumed the defense under a reservation, at which point likely the insurer for East Coast would have designated counsel to represent Shawmut and separate counsel to represent the third-party defendant. That was chosen not to be done. It was just completely rejected. The second reason why your question, this isn't a sham, is because it was arm's-length negotiation between Shawmut and the plaintiff. And here the special damages alleged of $431,000, and the actual judgment is for $300,000.
Mr. Lavoie, can I just hold on to your third point, because I was
I'll
getting...
try.
Okay. With respect to the first,
Yes.
Second, I didn't take Justice Spina is saying that there's a sham in this case, but how would one know in some other case? Because here there's a fairly lengthy record. I think that's
Yeah,
good.
yeah, that's right.
But on the first point, let's assume that an East Coast, that a sub does a really serious investigation, its own investigation. It's no witness. They never put the plywood down. They know they never put the plywood down. Why would we want to have a system that essentially puts the subcontractor, who after all is not in charge of the whole work site, into a kind of lose-lose? Yes, they can do it under a reservation of rights, but a reservation of rights suggests that they don't think there's liability, but there might be. I mean, that's a crude way of saying it. But essentially drags them in for something that they, in good faith, believe they had absolutely nothing to do with. Nobody from East Coast, I forget what East Coast does, brought any plywood onto the site.
Your Honor, the system is very close to that right now, and I would point out several things. First, the fact that there's also in the contract additional insured requirements.
Right.
And so there's been a transfer of the risk. The second thing is, under 14929C, the incident
but provision M, section M, whatever it's called, really seems to me to be saying, the general is in charge here, but let me tell you, subs, if you start acting negligently, I mean, I've got people on site, but you're going to be held responsible for that. But so the sub says, this is outrageous. It had nothing to do with me.
Your Honor, the statute 14929C actually requires that it merely be caused by the acts or omissions of the subcontractor, so it's not a negligent standard.
Okay.
So it is actually a very diminished standard. And in wrapping up, I'm getting close here.
No. You can go to your third point, if you can remember what it was.
If I can recall the third point, we had talked about, I think I've lost my third point.
Well, let me ask you while you're thinking. Let me ask you a question.
If you think about it on the way driving back to your law firm, you may, in this instance, and only this instance, you may send us a letter.
East Coast said that there would be economic chaos in the construction industry if we rule for the plaintiff in this case. And why do you say that's not so?
Your Honor, I think it goes back to the point Justice Cordy made initially. That is that if Shawmut decided to pay the $300,000 itself and then pursued East Coast would be in the same position it is in now. The only difference is there's been a transfer of the risk. Basically, the plaintiff has made a decision that he doesn't want to establish that Shawmut is 51 or more % negligent. He simply wants to establish that 1% of the claim is now against East Coast directly. And it can be done under the contract principle of breach of contract as opposed to the tort, which is why Chapter 152 doesn't apply in this circumstance.
So are you saying then that it doesn't make any difference who East Coast writes the check to? They're writing it to you rather than to Shawmut?
Well, you're Shawmut.
And what's the difference? Because you're Shawmut.
Well,
I mean, they're writing it to the plaintiff rather than to you.
I'm saying in the hypothetical, Your Honor, if Shawmut had paid, they would then be entitled to the money back from
But
East
they
Coast.
say you haven't paid, there's no loss. There's no actual loss.
I understand they say that. I read the indemnity provision as claims, damages, or loss. And there actually is a loss, that is the attorney's fees claim that we have. So we still have that loss for sure. And then we assert that the claim requires a loss when the agreement for judgment hits the
Were there other subs on this job?
Yes, Your Honor, there were other subs.
Does the record show why others had not been brought in on this case?
Back to my third point.
And therefore, you cannot send us a letter.
The record does not show the issue of other subcontractors. What it does is show that there was plywood which the plaintiff tripped over, which one could argue was open and obvious, and therefore the plaintiff's own negligence triggers the indemnity clause. The third point was that in the course of the underlying proceedings, the motion to strike the judgment, the plaintiff sought to have an evidentiary hearing, but didn't proffer any witnesses ultimately, and the court said there is no evidence of fraud or collusion here. So that was my third point, going back to why there is no...
But don't, I have a question. Go ahead, Chief, you may go ahead, but I have a question as
Okay,
well. Don't
Mr.
cut me.
Lavoie, just one thing. I know that Shawmut is not on the hook for that, but do you agree that what the plaintiff is going to try and do here is litigate only the question of negligence, and the damages are set at $300,000? That the most he can get is $300,000, the least he can get is zero, and there's no in-between?
It depends on how the court reads whether or not the loss is an indemnity loss. But yes, I would agree that there is an in-between to the extent the court says that the $300,000 is not a loss, and therefore the question is, are the attorney's fees the only loss?
Right, okay.
My question is this, and I think you may have touched on it. Do I understand it that the negligence, the East Coast negligence in this case, which triggers the indemnification, is the plaintiff's own negligence in not watching where he was walking?
Yes.
Which you then attribute to East Coast, which creates the indemnification?
That is one of the arguments, Your Honor. The other, another potential argument, which I'm not here to make for the plaintiff, but it could be that East Coast failed to train its employees to be careful of certain job site hazards.
Like tripping over wood?
Precisely.
All right. Now, it takes a lot of training for that. But let me...
I've heard the argument a number of times.
Yeah, I'm sure you have.
And the message never gets through.
Mr. Wainwright said something, and I saw it in the briefs, and I'll be darned if I could understand it, that East Coast agreed that the injured employee, his client, was partially at fault. Did East Coast agree to that in some binding way in the litigation?
Not that I'm aware of, Your Honor. I think what it might have been referring to is... Actually, I don't want to speak for Mr. Wainwright.
All right, so you don't know the answer to the question.
I'm unaware of any instance where East Coast has made any binding admission that the plaintiff was partially at fault.
All right,
Okay.
thank you.
Thank you.
Thank you, Your
Mr.
Honor.
Lavoie.